Question 1. Legislative process and statutory interpretation. During a comprehensive review of a process that needs improvement, a state legislature is considering an amendment to an existing consumer protection law. The current law prohibits deceptive trade practices but lacks specific language addressing online transactions. Legislators propose adding the phrase, including digital commerce and online transactions, to the statute. A legal challenge arises arguing that the amendment substantially changes the intent of the original law rather than merely clarifying it. Under the rules of statutory interpretation, which principle would best determine whether the amendment is a permissible clarification or an improper modification of legislative intent? The plain meaning rule, which dictates that words in a statute must be interpreted according to their ordinary meaning, regardless of legislative intent. B. The doctrine of expressio unius, which assumes that if a statute expressly includes certain things, others are excluded. C. The legislative history doctrine, which allows courts to examine congressional debates and reports to determine intent. D. The rule against surplusage discourages interpretations that render any statutory language redundant or meaningless. Answer is C. The legislative history doctrine. This doctrine allows courts to examine legislative records, debates, and reports to determine whether the amendment is a mere clarification of existing law or a substantive change. Courts frequently rely on legislative history to resolve ambiguities, especially when an amendment appears to expand or alter a statute's scope. A. The plain meaning rule applies when statutory language is unambiguous, but here the ambiguity lies in whether the amendment changes the law's intent. This rule does not address whether an amendment is clarification or substantive revision. B. The doctrine of expressio unius suggests that mentioning one category, e.g., digital commerce, implies exclusion of others. However, this principle is less relevant here because the issue is whether digital was originally included in the law's intent. D. The rule against surplusage discourages redundancy, but it does not resolve whether an amendment constitutes permissible clarification or an impermissible modification. Legislative intent plays a critical role in statutory interpretation, ensuring that courts apply laws as the legislature intended rather than rewriting them. Question 2. Regulatory agencies and administrative rulemaking. While investigating a complicated issue between different regulatory bodies, a dispute arises over whether a federal agency exceeded its authority when issuing a new rule restricting financial institutions from charging certain overdraft fees. The agency argues that it derived its rulemaking authority from a broadly worded statute directing it to ensure fair practices of financial institutions. Challenge the rule, claiming that Congress did not explicitly authorize such restrictions. Which legal doctrine will most likely determine the validity of the agency's rulemaking power? A. The major questions doctrine, which limits agency authority when making decisions of vast economic or political significance. B. The Chevron deference, which mandates courts defer to an agency's reasonable interpretation of ambiguous statutes. C. The non-delegation doctrine, which prohibits Congress from transferring legislative powers to agencies. D. The arbitrary and capricious standard, which invalidates rules if they lack rational basis. Answer is A. The major questions doctrine. This doctrine restricts agency rulemaking when an issue has significant political or economic implications unless Congress has clearly delegated the authority. The Supreme Court has applied this doctrine in cases where agencies attempt to regulate matters of great national importance without explicit congressional approval. B. Chevron deference applies when a statute is ambiguous and an interpretation is reasonable. However, courts increasingly limit its application, especially when dealing with major economic or political decisions. C. The non-delegation doctrine addresses the broader issue of whether Congress improperly transferred legislative power to an agency. While relevant, it is not the primary test used to assess whether an agency exceeded its delegated powers. D. The arbitrary and capricious standard under the Administrative Procedure Act applies when rule lacks justification, but it does not address the core issue of whether an agency had the authority to act in the first place. The major questions doctrine ensures that significant policy changes are made by elected legislators rather than unelected agency officials unless Congress explicitly authorizes them. Question 3. Criminal law and regulatory compliance. In a situation where formal requirements conflict with business operations, a multinational corporation discovers that its regional subsidiary engaged in questionable accounting practices to inflate earnings. A whistleblower reports the issue, triggering an investigation under the Foreign Corrupt Practices Act (FEPA). The corporation argues that the subsidiary acted independently and that its global headquarters was unaware of the violations. Under FEPA enforcement principles, which factor is most critical in determining corporate liability? A. Whether the corporation had a formal compliance program in place to prevent fraudulent accounting. B. Whether the subsidiary's actions provided direct financial benefit to the parent corporation. C. Whether the misconduct was explicitly authorized by senior executives at the parent corporation. D. Whether the whistleblower's report was filed with the appropriate federal agency before the investigation began. Answer is B. Whether the subsidiary's actions provided direct financial benefit to the parent corporation. Under the FEPA, parent companies can be held liable for the actions of their subsidiaries if they directly or indirectly benefit from the misconduct. Courts assess whether the parent exercised control over the subsidiary and whether it failed to detect or prevent violations. A compliance program is relevant but does not automatically absolve the corporation from liability. The effectiveness and enforcement of the program are crucial factors. C. Explicit authorization by senior executives would make liability more direct, but it is not a required element for FEPA enforcement. Even negligence in oversight can lead to liability. D. The timing of whistleblower report does not determine corporate liability. While early reporting may affect penalty mitigation, it does not negate violations. The FEPA imposes strict liability on companies benefiting from corrupt practices, emphasizing the importance of robust compliance programs and diligent oversight of subsidiaries. Question 4. In a high-stakes environment where multiple challenges intersect with regulatory obligations, a corporation operating across multiple states and countries faces a dilemma regarding the extraterritorial application of domestic laws. The company is headquartered in the US, but has subsidiaries in the European Union, EU, and China. Recently, it was fined the EU regulators for violating the General Data Protection Regulation (GDPR) while simultaneously being investigated by US authorities for non-compliance with the Foreign Corrupt Practices Act (FEPA). The company's legal team is struggling to navigate these conflicting legal obligations and determine which jurisdictions' laws take precedence. How should the company proceed to ensure compliance while mitigating legal risks? A. The company should strictly comply with U.S. laws as it is headquartered in the U.S. and argue that foreign regulations do not apply extraterritorially. B. The company should prioritize compliance with the most stringent regulatory framework even if it conflicts with domestic laws. C. The company should implement jurisdiction-specific compliance strategy, ensuring that each subsidiary adheres to the laws of the country in which it operates while maintaining an overarching corporate compliance framework. D. The company challenge the legality of foreign regulations in international courts to limit its exposure to conflicting legal systems. Answer C. The company should implement a jurisdiction-specific compliance strategy, ensuring that each subsidiary adheres to the laws of the country in which it operates while maintaining an overarching corporate compliance framework. Explanation. This scenario examines the extraterritorial application of laws and the conflict of laws across multiple jurisdictions. U.S. laws such as the FEPA have extraterritorial reach, meaning they apply to U.S. companies even when operating abroad. Similarly, DDR applies to any organization processing the data of EU citizens, regardless of location. Option is incorrect because foreign regulations GDPR and China's data laws do apply extraterritorially, and simply adhering to U.S. law does not shield the company from liability abroad. Option B is incorrect as prioritizing the strictest law without nuanced approach could result in legal violations in other jurisdictions. Option D is incorrect because challenging foreign regulations in international courts is unlikely to succeed and may result in prolonged legal battles. Jurisdiction-specific compliance strategy, option C, ensures compliance with local laws while maintaining global compliance framework to manage risks effectively. This aligns with the principles of international regulatory harmonization and corporate compliance strategies. Question 5. During a major transformation where existing methods of financial oversight are being restructured, a regulatory agency introduces new banking regulations aimed at preventing financial crises. However, the regulations impose significant compliance costs on small financial institutions, potentially leading to market consolidation where only large banks can afford to operate. A group of community banks challenge regulations, arguing that they violate the Administrative Procedure Act, due to inadequate consideration of economic impact. How should a court evaluate this claim? A. The court should defer to the regulatory agency's expertise and uphold the rule unless it is clearly unconstitutional. B. The court should assess whether the rulemaking process followed the APA's notice and comment procedures and whether the agency provided reasoned explanation for its decision. C. The court should strike down the regulation if it imposes disproportionate costs on small financial institutions. D. The court should allow Congress intervene before ruling on the matter, as financial regulation falls within legislative authority. Answer. B. The court should assess whether the rulemaking process followed the APA's notice and comment procedures and whether the agency provided reasoned explanation for its decision. Explanation. The Administrative Procedure Act, APA, governs federal rulemaking, ensuring agencies follow due process in promulgating regulations. Courts assess whether agencies comply with procedural requirements and engage in reasoned decision-making. Option is incorrect because courts do not grant unlimited deference. They apply the Chevron doctrine or arbitrary and capricious standard under the APA to assess agency actions. Option C is incorrect because courts do not invalidate regulations solely due to economic burden. They assess whether agencies justified their decisions based on statutory authority and evidence. Option D is incorrect because judicial review under the APA is independent of congressional intervention. By choosing option B, courts determine whether the agency followed proper procedures, e.g. notice and comment requirements, provided reasoned explanation considering economic impacts, acted within statutory authority. This case highlights the balance between regulatory goals and economic feasibility, critical issue in financial and economic regulation. Question 6. In a situation where formal requirements conflict with the practical application of consumer protection laws, a state legislature enacts a statute requiring companies to disclose all arbitration clauses in consumer contracts in bold 12-point font. However, a major telecommunications company continues using fine print arbitration clauses in its contracts. Consumers sue, arguing that the company's failure to highlight the arbitration makes it unenforceable. The company contends that the Federal Arbitration Act preempts state law. How should court resolve this issue? A. The state law prevails, as consumer protection is traditional area of state authority. B. The FAR preempts the state law, rendering the disclosure requirement unenforceable. C. The court should evaluate the state law's intent and determine whether it creates an undue burden on arbitration agreements. D. The court should allow consumers to choose whether to abide by arbitration clauses based on the clarity of disclosure. Answer. B. The FAR preempts the state law, rendering the disclosure requirement unenforceable. Explanation. The Federal Arbitration Act, FAR, preempts conflicting state laws that undermine the enforceability of arbitration agreements. The Supreme Court has consistently ruled in cases like AT&T Mobile LLC v. Concepcion 2011 that state laws cannot impose additional requirements on arbitration clauses beyond federal law permits. Option is incorrect because federal law supersedes conflicting state consumer protection laws in arbitration matters. Option C is incorrect because the intent of a state law does not override federal preemption. Option D is incorrect because contract enforceability is a legal question, not a consumer choice issue. By choosing option B, courts reinforce the supremacy of the FAR over state laws that attempt to impose additional burdens on arbitration agreements, demonstrating the importance of federal preemption in contract and consumer protection law. Question 7. While analyzing the root causes of sequential problems in environmental enforcement, a state agency struggles to regulate industrial pollution due to conflicting mandates under state and federal law. Some businesses exploit legal loopholes to avoid penalties, arguing that the state cannot enforce stricter standards than federal regulations. The state insists on its right to impose more stringent environmental rules. Under what conditions can a state enact stricter environmental regulations than federal law? A. States can impose stricter environmental standards as long as they do not directly conflict with federal law. B. States cannot impose any environmental regulations that exceed federal requirements. C. The Environmental Protection Agency (EPA) must approve any state regulations before they can take effect. D. States may impose stricter regulations only if Congress explicitly grants them the power to do so. Answer A. States can impose stricter environmental standards as long as they do not directly conflict with federal law. Explanation. The Clean Air Act, and Clean Water Act allow states to implement stricter environmental protections than federal baselines, provided they do not contradict federal law. Option B is incorrect because federal environmental laws often establish minimum standards, not maximum limits. Option C is incorrect because states do not need EPA approval for setting stricter rules unless federal law explicitly requires it. Option D is incorrect because states have inherent authority under the 10th Amendment to regulate within their jurisdiction unless preempted by federal law. Choosing option aligns with federalism principles, where states can serve as environmental policy leaders, as seen in California's stricter emission standards under the COS waiver provisions. Question 8. During a major transformation where existing methods of financial oversight are being restructured, a new federal regulation requires all investment firms to report real-time transactions to a central monitoring agency to increase market transparency. However, compliance with this rule imposes substantial technological and operational costs, particularly on smaller firms. A coalition of investment firms challenges the regulator, arguing that it constitutes an undue burden and lacks statutory authority. If the case reaches the Supreme Court, what is the most likely legal standard the court will apply to determine the validity of the regulation? A. The court will assess whether a regulation is a necessary and proper means of achieving the agency's goals. B. The court will apply the Chevron doctrine to determine whether the agency's interpretation of the law is reasonable. C. The court will strike down the regulation if it imposes significant financial costs on businesses. D. The court will defer to Congress to decide whether the rule is economically viable. Answer. B. The court will apply the Chevron doctrine to determine whether the agency's interpretation of the law is reasonable. Explanation. This case concerns administrative law and the extent of agency power under the Chevron doctrine. Chevron U.S. Inc. v. Natural Resources Defense Council, Inc. 1984. When courts review an agency's rulemaking, they first ask whether Congress has spoken directly on the issue. If the statute is clear, that interpretation governs. If the statute is ambiguous, courts determine whether the agency's interpretation is reasonable. Option is incorrect because the necessary and proper clause applies to Congress, not agencies. Option C is incorrect because courts do not strike down regulations based solely on cost. They assess statutory and constitutional validity. Option D is incorrect because courts evaluate the legality of agency rules independently of congressional decisions. Thus, the Chevron doctrine governs regulatory challenges, ensuring agencies have latitude in interpreting ambiguous statutes. Question 9. In a situation where formal requirements conflict with the practical application of consumer protection laws, a state legislature passes a law requiring all digital platforms to provide users with an explicit option to decline data collection before using their services. A major technology company sues, arguing that this state law is preempted by federal regulations under the Federal Trade Commission (FTC) Act and violates the cause by interfering with interstate commerce. How should a federal court evaluate this claim? A. The court should uphold the state law because consumer protection is traditionally a state responsibility. B. The court should strike down the state law if it directly conflicts with federal regulations. C. The court should allow the law to stand unless Congress explicitly prohibits such regulations. D. The court should defer to the technology companies' policy choices, as private businesses have right to set their own data policies. Answer. B. The court should strike down the state law if it directly conflicts with federal regulations. Explanation. The Supremacy Clause, Article Clause 2, establishes that federal law preempts conflicting state laws. Courts analyze preemption in three ways. Express preemption. Congress explicitly states that federal law overrides state law. Field preemption. Federal law is so comprehensive that it occupies the field, leaving room for state regulations. Conflict preemption. When state law directly conflicts with federal law, making compliance with both impossible. Option is incorrect because consumer protection laws, while often state-driven, cannot override conflicting federal regulations. Option C is incorrect because Congress does not need to explicitly prohibit state law for preemption to apply. Option D is incorrect because corporate autonomy does not supersede valid regulatory requirements. If the FTC has established federal framework for data protection, the state law would likely be preempted under conflict preemption principles. Question 10. While analyzing the root causes of sequential problems in environmental enforcement, a chemical plant repeatedly fails to meet state-mandated emissions limits. The state environmental agency issues fines, but the company continues to violate the standards, claiming compliance is technologically unfeasible. The agency seeks to shut down the plan, but the company argues that the state lacks authority since the Environmental Protection Agency (EPA) has not taken enforcement action under the Clean Air Act. Who has the stronger legal argument? A. The state, because environmental laws allow states to impose stricter standards than federal law. B. The company, because federal environmental laws preempt state enforcement actions. C. The state, but only if it can prove that the EPA has delegated enforcement authority to it. D. The company, because it cannot be held liable for violating standards that are technologically unfeasible. Answer: B. The company, because federal environmental laws preempt state enforcement actions. Explanation: under the Clean Air Act, states have the authority to establish stricter environmental regulations than federal minimums, unless explicitly preempted. Courts recognize cooperative federalism in environmental regulation, where states play a key enforcement role. Option B is incorrect because the CA expressly allows states to enforce environmental laws independently. Option C is incorrect because states do not need specific EPA approval to enforce their own environmental laws. Option D is incorrect because technological feasibility is not a blanket defense against legal compliance. Thus, states retain authority to regulate and enforce environmental protections even when federal agencies remain inactive. Question 11. As new industry standards begin to reshape regulatory frameworks and new automotive safety regulation requires all vehicles sold in the U.S. to include advanced driver assistance systems (AS) by 2030. A group of small car manufacturers challenges the rule, arguing that it unfairly benefits larger manufacturers who can afford the transition. If the case is brought before a federal court, what is the most likely constitutional issue that will be evaluated? A. Whether the regulation violates the Equal Protection Clause by imposing unequal burdens on different manufacturers. B. Whether the rule constitutes an unconstitutional taking under the Fifth Amendment. C. Whether the agency exceeded its authority under the Administrative Procedure Act, APA. D. Whether the regulation interferes with state-level automotive safety laws. Answer: C. Whether the agency exceeded its authority under the Administrative Procedure Act, APA. Explanation: this case primarily concerns administrative law and whether the agency acted within its statutory authority. Courts will evaluate the rule under the Administrative Procedure Act, APA, to determine, did the agency have the authority to create the rule? Was the rule arbitrary, capricious, or an abuse of discretion? Option is incorrect because economic disadvantages between companies do not constitute a valid equal protection challenge unless based on a suspect classification, e.g. race, gender. Option B is incorrect because regulatory compliance costs do not constitute a taking under the Takings Clause. Option D is incorrect because federal safety regulations generally preempt conflicting state laws under the Supremacy Clause. Thus, the validity of the regulation hinges on whether the agency followed proper rulemaking procedures under the APA. Question 12. When evaluating the impact of competing legal interpretations in contract disputes, a software developer enters into a contract with a cybersecurity firm to provide continuous security updates for 5 years. After 2 years, the developer claims that the agreement was impossible to fulfill due to unforeseen technological advancements. The firm sues for breach of contract. What legal principle will the court most likely consider? A. The doctrine of frustration of purpose. B. The doctrine of impossibility of performance. C. The principle of anticipatory repudiation. D. The standard of unconscionability. Answer: B. The doctrine of impossibility of performance. Explanation: the doctrine of impossibility of performance applies when unforeseen events make fulfilling the contract objectively impossible. Courts assess: was the impossibility truly unforeseeable? Did external conditions prevent performance? Option is incorrect because frustration of purpose applies when the reason for entering the contract is destroyed, not the ability to perform. Option C is incorrect because anticipatory repudiation involves a party clearly refusing to perform before the deadline. Option D is incorrect because unconscionability refers to unfair contract terms, not performance issues. Thus, if technological advancements make compliance impossible, the developer may have a valid defense under impossibility of performance. Question 13. Given the precedent set by landmark rulings on free speech, a state legislature passes a law prohibiting social media companies from removing political content, arguing that it violates free speech. A large platform challenges the law. claiming that it infringes on its own First Amendment rights. What is the most likely constitutional issue at play? A. Whether social media companies qualify as state actors under First Amendment law. B. Whether content moderation policies violate the Equal Protection Clause. C. Whether the law infringes on the company's right to editorial discretion. D. Whether the law violates the Commerce Clause by interfering with national markets. Answer: C. Whether the law infringes on the company's right to editorial discretion. Explanation: in Miami Herald v. Tornillo, 1974, and Packingham v. North Carolina, 2017, the Supreme Court recognized that private entities have editorial discretion over speech on their platforms. Courts will consider: do private companies have free speech rights? Yes, under the First Amendment. Does the law improperly compel speech? Forcing platforms to host content may violate their rights. Option is incorrect because social media platforms are not government entities and are not bound by the First Amendment in the same way. Option B is incorrect because content removal does not involve equal protection claims. Option D is incorrect because the Commerce Clause applies more broadly to economic restrictions. Thus, forcing platforms to host political speech may violate their First Amendment rights. Question 14. As industries increasingly rely on artificial intelligence to drive decision-making, a financial services firm implements an AI-powered system that automatically approves or denies mortgage applications. A rejected applicant sues, alleging that the AI system discriminates against minority borrowers in violation of the Fair Housing Act (FHA). What legal principle will be central to the case? A. Whether AI decisions qualify as intentional discrimination under federal law. B. Whether AI algorithms can be challenged under disparate impact analysis. C. Whether the firm has immunity under Section 230 of the Communications Decency Act. D. Whether the applicant has standing under contract law rather than civil rights law. Answer: B. Whether AI algorithms can be challenged under disparate impact analysis. Explanation: under the Fair Housing Act (FHA), discrimination claims can be based on disparate impact, meaning policies that appear neutral but disproportionately harm protected groups. Courts will consider: does the AI system result in biased outcomes? Can the company provide a legitimate business justification for its algorithmic decisions? Option is incorrect because proving intentional discrimination is not required in disparate impact cases. Option C is incorrect because Section 230 applies to online content platforms, not financial institutions. Option D is incorrect because the FHA, or contract law, governs fair lending practices. Thus, AI-driven lending decisions must be scrutinized for unintended discriminatory effects under disparate impact analysis. Question 15. When evaluating the ethical implications of emerging healthcare technologies, a biotech company develops a gene-editing therapy to cure a rare genetic disorder. However, the treatment is extremely expensive and insurance companies refuse to cover it. Patients argue that the refusal violates medical ethics and their right to access life-saving treatments. What ethical principle is most relevant to this debate? A. Utilitarianism, because cost-effectiveness should determine access. B. Justice, because access to healthcare should be equitable. C. Autonomy, because patients should decide their treatment options. D. Non-maleficence, because financial barriers should not cause harm. Answer: B. Justice, because access to healthcare should be equitable. Explanation: the principle of justice in medical ethics emphasizes fair distribution of healthcare resources. Courts and policymakers will consider: should life-saving treatments be available regardless of cost? Do insurance policies create unequal access to cutting-edge treatments? Option is incorrect because a purely utilitarian approach might justify withholding expensive treatments. Option C is incorrect because patient autonomy applies to decision-making, not financial access. Option D is incorrect because non-maleficence concerns preventing harm, but financial policies do not directly harm patients. Thus, justice is the most relevant ethical principle in cases of unequal healthcare access. Question 16. Given the complex regulatory landscape surrounding environmental protections, a coal company challenges a new Environmental Protection Agency (EPA) regulation that limits carbon emissions. The company argues that the EPA exceeded its authority by implementing rules not explicitly authorized by Congress. What is the most relevant legal doctrine? A. Chevron deference, which grants agencies flexibility in interpreting statutes. B. The Major Questions Doctrine, which limits agency power on important issues. C. The Non-Delegation Doctrine, which prevents Congress from outsourcing its powers. D. The Dormant Commerce Clause, which restricts state-level environmental laws. Answer: B. The major questions doctrine, which limits agency power on important issues. Explanation: the major questions doctrine applies when an agency imposes significant economic or political changes without clear congressional approval. Courts will ask, did Congress clearly authorize the EPA to regulate carbon emissions in this way? Does the rule impose major policy changes beyond the agency's expertise? Option is incorrect because Chevron deference applies when statutes are ambiguous, but major policy shifts require explicit congressional approval. Option C is incorrect because the non-delegation doctrine is rarely used and applies to Congress delegating legislative powers, not agency rulemaking. Option D is incorrect because the Dormant Commerce Clause concerns state laws affecting interstate commerce, not federal regulations. Thus, courts will likely scrutinize the EPA's authority under the major questions doctrine. Question 17. As data privacy concerns grow in the digital economy, a social media company collects vast amounts of user data and sells it to advertisers. A consumer advocacy group files a lawsuit claiming the practice violates users' privacy rights under the Fourth Amendment. What is the main legal issue? A. Whether the third-party doctrine eliminates Fourth Amendment protection. B. Whether the Stored Communications Act (SCA) protects user data. C. Whether the California Consumer Privacy Act (CCPA) preempts federal law. D. Whether the company qualifies as a government actor under constitutional law. Answer A. Whether the third-party doctrine eliminates Fourth Amendment protection. Explanation: under the third-party doctrine, individuals lose Fourth Amendment protections when they voluntarily share data with third parties. Courts will examine, did users consent to data collection? Do evolving digital privacy concerns require reconsideration of the doctrine? Option B is incorrect because the SCA protects stored electronic communications but does not override the third-party doctrine. Option C is incorrect because state laws like the CCPA do not override federal constitutional interpretations. Option D is incorrect because private companies are not state actors subject to constitutional privacy restrictions. Thus, the case hinges on whether the third-party doctrine remains valid in the digital age. Question 18. As automation reshapes the modern workforce, a major retail chain introduces automated checkout systems, significantly reducing the need for human cashiers. The affected employees sue the company, arguing that mass layoffs due to automation violate labor laws and the principle of wrongful termination. Which legal framework is most relevant in determining the case outcome? A. Employment doctrine, which allows termination without cause. B. National Labor Relations Act (ARA), which protects workers from unfair labor practices. C. Americans with Disabilities Act (ADA), which protects workers with disabilities from discrimination. D. Fair Labor Standards Act (FLSA), which governs minimum wage and overtime rules. Answer A. Employment doctrine, which allows termination without cause. Explanation: the at-will employment doctrine permits employers to terminate workers for any reason except for illegal discrimination or contractual obligations. Courts will consider, was there an employment contract protecting workers from layoffs? Did the company violate public policy such as discrimination laws? Option B is incorrect because the ARA protects collective bargaining rights but does not prevent layoffs due to automation. Option C is incorrect because the ADA applies to discrimination based on disability, not automation-driven layoffs. Option D is incorrect because the FLSA addresses wage laws, not termination policies. Thus, automation-driven layoffs are generally legal unless contract terms or discrimination laws are violated. Question 19. Given the rapid advancements in financial technology, a fintech company develops an algorithmic trading system that executes trades within milliseconds, giving its clients a significant advantage over traditional traders. Regulators investigate whether this practice, known as high-frequency trading (HFT), constitutes market manipulation. What is the key legal issue? A. Does HFT violate the Securities Exchange Act of 1934 by creating an unfair market? B. Does HFT benefit all investors by increasing market efficiency? C. Does the Federal Trade Commission (FTC) have jurisdiction over HFT practices? D. Does the Sherman Antitrust Act apply to algorithmic trading? Answer A. Does HFT violate the Securities Exchange Act of 1934 by creating an unfair market? Explanation: the Securities Exchange Act of 1934 prohibits market manipulation that distorts fair trading. Regulators will examine, does HFT create artificial price movements or disadvantage other traders? Which FT firms engage in illegal spoofing or layering tactics? Option B is incorrect because HFT may improve liquidity. It can also create unfair advantages. Option C is incorrect because the FTC primarily regulates consumer protection, not securities markets. Option D is incorrect because the Sherman Antitrust Act addresses monopolistic behavior, not stock market manipulation. Thus, HFT practices must comply with securities laws to ensure fair market conditions. Question 20. As cybersecurity threats become more sophisticated, a hospital network suffers a ransomware attack, locking patient records and disrupting emergency services. The attackers demand cryptocurrency payments in exchange for decryption keys. Under federal law, how should the hospital respond? A. Pay the ransom immediately to restore critical services. B. Report the attack to federal authorities before taking further action. C. Negotiate with the hackers under the National Cybersecurity Protection Act. D. Pursue civil litigation against the ransomware group. Answer. B. Report the attack to federal authorities before taking further action. Explanation. Under the Cybersecurity Information Sharing Act, CISA, and federal anti-ransomware guidelines, organizations must report attacks to law enforcement agencies, e.g., FBI, CISA, avoid paying ransoms as this can fund further cybercrime. Option is incorrect because paying the ransom is discouraged and sometimes illegal if linked to sanctioned entities. Option C is incorrect because the National Cybersecurity Protection Act does not permit negotiation with hackers. Option D is incorrect because pursuing litigation against anonymous cybercriminals is rarely effective. Thus, prompt reporting and cybersecurity measures are the recommended response. Question 21. With global supply chains facing increasing disruptions, a major automobile manufacturer experiences delays in obtaining semiconductor chips, causing production stoppages. The company sues its supplier for breach of contract. What legal defense might the supplier use? A. Force majeure clause, excusing contract performance due to unforeseen events. B. Uniform Commercial Code UC, provisions on merchantability. C. Federal Trade Commission, FTC, regulations on consumer protection. D. Antitrust exemptions under the Sherman Act. Answer. A. Force majeure clause, excusing contract performance due to unforeseen events. Explanation. A force majeure clause allows a supplier to avoid liability if a contract explicitly includes unforeseen disruptions, e.g., pandemics, natural disasters, or government restrictions. Court will examine, does the contract specify supply chain disruptions as a force majeure event? Did the supplier make reasonable efforts to mitigate the delay? Option B is incorrect because UC provisions relate to product quality, not delivery delays. Option C is incorrect because FTC regulations protect consumers, not BB contracts. Option D is incorrect because antitrust laws do not apply to supply chain contract disputes. Thus, force majeure is the most likely defense in supply chain disruption cases. Question 22. As climate change drives shifts in global energy policies, a state government introduces a law banning gasoline-powered vehicles by 2035. Auto manufacturers challenge the law in court, arguing it violates federal preemption principles. What legal argument might the state use to defend its law? A. The Clean Air Act gives states authority to regulate vehicle emissions. B. The Commerce Clause allows states to regulate trade within their borders. C. The Supremacy Clause prevents federal intervention in state laws. D. The Takings Clause allows states to compensate manufacturers for lost revenue. Answer. A. The Clean Air Act gives states authority to regulate vehicle emissions. Explanation. Under the Clean Air Act, states, especially California and those adopting similar standards, can implement stricter emissions regulations. Courts will consider, did the state receive waiver from the EPA? Does the law unduly burden interstate commerce? Option B is incorrect because while states can regulate internal trade, they cannot impose rules affecting national markets. Option C is incorrect because the Supremacy Clause supports federal, not state, authority. Option D is incorrect because the Takings Clause applies to physical property, not future sales bans. Thus, state emissions laws must align with federal regulations but can be stricter with EPA approval. Question 23. In a high-stakes environment where multiple challenges must be managed simultaneously, a pharmaceutical company is conducting clinical trials for a new drug under strict FDA regulations. However, midway through the trials, new side effects emerge, prompting concerns about patient safety and the need to halt the study. The company's executives must decide whether to continue, pause, or modify the trials. Which regulatory or principle should guide their decision-making process. A. The precautionary principle, prioritizing safety over potential benefits. B. The efficiency principle, focusing on maintaining progress in drug development. C. The market readiness doctrine, ensuring the drug reaches consumers quickly. D. The profitability mandate, considering financial investment and shareholder value. Answer A. The precautionary principle, prioritizing safety over potential benefits. Explanation: the precautionary principle is central to clinical research ethics, requiring that companies prioritize patient safety when uncertainties arise. In this case, the company must assess the severity and frequency of the new side effects, determine if additional risk mitigation measures are needed, follow FDA guidelines on trial modifications or suspensions. Option B is incorrect because efficiency cannot override safety in clinical trials. Option C is incorrect because fast-tracking a drug without proper safety measures violates FDA protocols. Option D is incorrect because financial interests must never compromise patient well-being. Thus, the company must act in the interest of public health and regulatory compliance. Question 24. During a comprehensive review of a process that needs improvement, a large tech company is reviewing its remote work policy after noticing decreased productivity and increased security concerns. The company must decide whether to require employees to return to the office, implement hybrid work models, or invest in remote security upgrades. Which of the following factors should play the biggest role in their decision? A. Employee satisfaction and work-life balance. B. Cybersecurity risks and potential data breaches. C. Real estate costs and savings from reduced office space. D. Legal compliance with labor and workplace laws. Answer B. Cybersecurity risks and potential data breaches. Explanation: while all factors are relevant, cybersecurity risks and potential data breaches must be the primary concern in a tech company handling sensitive information. The review should focus on strengthening remote security protocols. D. VPNs, multi-factor authentication, determining if remote work increases exposure to cyber threats, ensuring compliance with regulations such as DDR-EPA. Option is important but secondary to security concerns. Option C is incorrect because cost savings should not compromise data protection. Option D is incorrect because while labor laws matter, cybersecurity breaches can cause legal and financial damages. Thus, the company must first address security vulnerabilities before finalizing its remote work strategy. Question 25. While analyzing the root causes of sequential problems in a supply chain, a global electronics company is facing production delays due to shortages of key materials. However, even after securing alternative suppliers, shipment bottlenecks persist, leading to missed deadlines and lost revenue. What systemic issues should be investigated to resolve these recurring problems? A. Weaknesses in supply diversification and contingency planning. B. Over-reliance on domestic production facilities. C. Failure to anticipate technological advancements. D. Inadequate marketing strategies affecting demand forecasting. Answer A. Weaknesses in supplier diversification and contingency planning. Explanation: the company's failure to diversify suppliers and create contingency plans is the core issue. To solve this, leadership must assess supply chain risks and develop alternative sourcing strategies, negotiate contracts with multiple suppliers to reduce dependency, implement real-time logistics tracking to monitor potential delays. Option B is incorrect because domestic production is not the primary issue. Option C is incorrect because the issue is logistical, not technological. Option D is incorrect because demand forecasting is not the root cause of shipment delays. Thus, proactive risk management and supplier diversification are key to supply chain stability. Question 26. In a situation where formal requirements conflict with practical constraints, a government agency is implementing new data privacy regulations requiring strict encryption protocols for all stored data. However, smaller businesses complain that complying with these standards will be too costly and complex. What is the best approach to balance security requirements with practical constraints? A. Offer financial aid or subsidies to small businesses for compliance. B. Lower security standards to accommodate smaller businesses. C. Exclude small businesses from the regulation entirely. D. Delay enforcement until all businesses can fully comply. Answer A. Offer financial aid or subsidies to small businesses for compliance. Explanation: the agency must ensure security compliance while preventing excessive financial burdens. The best approach is to provide grants or low-cost cybersecurity tools to small businesses, offer phased compliance deadlines to ease financial strain, maintain core security standards to protect sensitive data. Option B is incorrect because reducing security standards weakens overall data protection. Option C is incorrect because small businesses also handle sensitive customer data. Option D is incorrect because delays increase exposure to data breaches. Thus, financial assistance and gradual enforcement ensure compliance without major disruptions. Question 27. When scaling up operations that experience significant bottlenecks, a fast-growing e-commerce platform faces technical failures due to a sudden increase in user traffic. Despite upgrading servers, system crashes persist during peak hours. What is the most effective solution to ensure long-term scalability? A. Implement cloud-based load balancing and auto-scaling features. B. Increase the number of customer service representatives. C. Reduce the number of daily promotions to limit website traffic. D. Manually adjust server capacity based on expected demand. Answer A. Implement cloud-based load balancing and auto-scaling features. Explanation: the most scalable approach is cloud-based load balancing, which dynamically distributes traffic. Steps include using cloud-based infrastructure for automatic resource scaling, optimizing databases to handle concurrent requests efficiently, employing caching techniques to reduce server load. Option B is incorrect because more customer service staff won't fix technical bottlenecks. Option C is incorrect because limiting promotions is short-term fix, not long-term solution. Option D is incorrect because manual server adjustments are inefficient for scaling needs. Thus, cloud scalability solutions are critical for sustainable growth. Question 28. When implementing new protocols in a shared environment where multiple teams must collaborate, a multinational corporation is rolling out a new project management system that will standardize workflows across different regional offices. However, some teams resist the change, citing concerns about compatibility with existing processes and potential slowdowns in productivity. What is the most effective strategy to ensure a transition? A. Mandate immediate compliance, enforcing strict deadlines for adoption. B. Create a phased implementation plan with training and support. C. Allow each team to choose whether they want to adopt the system. D. Provide financial incentives for teams that transition quickly. Answer A. Mandate immediate compliance, enforcing strict deadlines for adoption. Explanation: a phased implementation ensures gradual adaptation while minimizing disruption. The transition plan should include comprehensive training sessions to familiarize employees with the new system, pilot testing in select teams before full-scale deployment, continuous feedback loops to adjust the system based on user concerns. Option is incorrect because forcing compliance without preparation can cause resistance. Option C is incorrect because allowing optional adoption defeats the purpose of standardization. Option D is incorrect because financial incentives won't address compatibility concerns. Thus, structured training and gradual adoption ensure smooth and effective transition. Question 29. During an emergency response where multiple areas are impacted simultaneously, a major cybersecurity breach affects a hospital network, causing electronic health records to become inaccessible. Critical departments, such as emergency care, surgery, and pharmacy, are unable to access patient data. What should be the first response to ensure patient safety and restore system functionality? A. Immediately shut down all its systems to prevent further infiltration. B. Isolate affected servers while maintaining backup access for critical systems. C. Switch to manual documentation and postpone all non-urgent procedures. D. Notify law enforcement and wait for their guidance before taking action. Answer B. Isolate affected servers while maintaining backup access for critical systems. Explanation: the most critical priority in a healthcare setting is maintaining continuity of patient care while securing data. The response plan should isolate compromised servers to prevent further spread, activate backup systems to restore access to patient records, implement emergency cybersecurity protocols while investigations begin. Option is incorrect because shutting down all its systems could disrupt critical operations. Option C is only a partial solution and does not address the root cause of the breach. Option D is incorrect because delaying action could worsen the impact. Thus, a rapid, controlled response ensures security while keeping essential hospital functions operational. Question 30. In a scenario where efficiency decreases across multiple interconnected departments, A financial services company is experiencing a backlog of customer transactions, leading to delays in processing payments and account updates. While the customer service team faces complaints, the team blames outdated infrastructure and the operations team cites staff shortages. Which root cause analysis approach is best suited to identify and address the decline? A. Use the 5 whys technique to trace the issue to its origin. B. Immediately increase staffing in customer service. C. Upgrade its systems without investigating process inefficiencies. D. Shift focus to employee performance reviews to find inefficiencies. Answer: A. Use the 5 whys technique to trace the issue to its origin. Explanation: the 5 whys technique is a structured problem-solving method that helps identify the true root cause of inefficiencies by repeatedly asking why. To trace the issue, the company should analyze transaction delays and pinpoint where bottlenecks occur, determine whether the issue stems from system failures, staffing, or workflow inefficiencies, implement targeted improvements based on findings. Option B is incorrect because staffing increases may not address the real problem. Option C is incorrect because upgrading it without understanding the cause may be ineffective. Option D is incorrect because blaming individual employees ignores systemic issues. Thus, a structured root cause analysis approach ensures a sustainable solution to efficiency problems.